Corruption is paid by the poor. Good evening and welcome. This is Face the Nation. Our topic of discussion today is the Anti-Corruption Act that will come into force on the 15th of September. That is 2 days from now. What is this act really? To discuss all this and more, we've invited 4 guests to our studio this evening as well. Joining us this evening on the show are Attorney at Law, Mr. U.R. De Silva, President's Counsel; Attorney at Law, Pumi Madhushani, Legal Officer of TISL; Chandrasena Maliyadda, former Minister Secretary of Plan Implementation, as well as Attorney at Law, J.M. Vijay Bandara. Joining me on Face the Nation tonight to pose questions to the panelists are Nadeem Majid on to my immediate right, and on to my immediate left is Niresh Thambi, who is the Consultant English News Director at Newsfirst. You also can join in as far as the conversation is concerned. You can message your questions to 076 656 5353. The number once again 076 656 5353. Please make sure that you send in your messages via WhatsApp. Let's start off tonight's discussion with Mr. U.R. De Silva, President's Counsel, on his opinions about the Anti-Corruption Act that will come into force 2 days from now. Your time starts now.
Shamil, this was discussed from 2015, whether we are going to draft a bill with regard to anti-corruption, because United Nations Anti-Corruption Convention, our Sri Lanka signed that convention and agreed to implement that in our country, but unfortunately till 2015 they didn't do anything. Earlier we had this 1994 Bribery and Corruption Act. People were not satisfied with it. Even the governing bodies, they are not satisfied with that particular bill, particular act. So they agreed to draft a separate anti-corruption act with regard to the corruption that's there in our country. So we tried our best to have a good law with regard to anti-corruption, but various difficulties were there. Then the government has changed, then new government came, Gotabaya Rajapaksa's government, so they didn't do anything with regard to that particular act. Thereafter, Vijayadasa Rajapaksa, who was behind this, was very, very interested in this, getting this bill done. So he asked all the stakeholders to come together and discuss at length, and thereafter only this bill came to Parliament. And fortunately, the Parliament it was passed without any division. So that was the case of this particular act. Now, when we go into that, what are the new things that are there in this particular act is the important thing which we have to discuss. The people should know that now the bribery department, we have commissioners. The commissioners, of course, earlier was appointed by the president. Mostly the Supreme Court judges, after retirement, they were appointed, and then various other institutions, police also, various IGPs, they were appointed after their retirement. But people were not satisfied with their conduct, and they were not responsible, or they are not in a position to divulge what they were doing. So this particular act specifically states that every 4 months the Bribery Corruption Commission should inform the Parliament what is the progress of the particular inquiry, or what is the progress of the inquiries they have done. So they can't just say this is an independent body, we are not in a position to say anything, but they are responsible to Parliament, and Parliament can question what is happening in the particular area. Now we know some of the files that people, the opposition people, they go inside the bribery department, they come out and they face for the interviews, but nothing will happen. We don't know what's happening. So then the people say they are not working on it. Now in this particular act, Shamil, it is important state Parliament has the power to question them and control them also, and then if they are not doing anything properly, they will say that we are not allocating any money.
Mr. Disula, very quickly before I move on to Mr. Maliadda, we know that since 2015 there were discussions about bringing forth an anti-corruption act or law in Sri Lanka. However, if you look at the last few months, Sri Lanka has hurried this act in question because of the IMF regulations stipulating that it's important to have an anti-corruption legal framework in the country. Don't you think that this bill was rushed because of lenders pressing the government to bring in laws to the country?
At least they have done their duty, because of that. In fact, it is the main cause, because we want to show that though we agreed in 2015, we have done anything. So we want to show at this juncture that we are going to do this, and then we are since we have signed the convention, we are ready to implement it.
Right. Thank you very much, Mr. U.R. De Silva, President's Counsel. I now move my attention towards Mr. Chandrasen Malia, the former Ministry Secretary of Plan Implementation.
Thank you very much and good evening. So I look the fish out of water because I'm seated among three legal luminaries. I'm a layman. As far as I'm concerned, I was a die-hard bureaucrat, So my views, I can learn the legal aspects. But if you look at the anti-corruption bill, it's a timely needed thing for the country, because there are voices raised locally as well as outside the country that corruption is rampant in Sri Lanka. So it has been brought to the notice by IMF, it was brought out by the UNHCR, HRC, and then also World Bank, ADB. All the multilateral donors and the multilateral agencies are drawing the attention. And also there is a concern within the citizenry, locally, that the corruption is rampant in the public sector, and also that the act was drafted by the legal draftman department, and it was vetted by the Attorney General, and it was presented to the Parliament by another legal expert. So it's a 100% legal act. So I am, as a bureaucrat, I feel that, no offense to these three legal experts, I feel that there should have been some contribution, some insights coming from the public sector, because the anti-corruption is legal, but corruption is not legal, it is illegal, and it is happening. It is according to the bill. If you read the bill, 164 clauses, you will see that fingers are pointed at the public sector. So I am being a public servant. I feel that whether we are committing offences, or whether we are preventing offences, or we are avoiding offences, or we are keeping our eyes closed to those offences, so it is happening in the public sector. So therefore there should have been some lessons learning from the public sector, pluses and minuses, to improve the context of the bill. So I feel that without any offense, offense to these three legal gentlemen, lady and the gentleman, I feel that there should have been some contribution made by the public sector officials. But as far as I know, I don't think there was much consultation with the public sector.
Very quickly, Mr. Maliadda, you said that fingers are pointed at the public sector through this act in question.
Yes.
But don't you think that the public sector is what is concerning right now as far as anti-corruption is concerned in the country? And that is where everything needs to be arrested and corruption should stop. And that is why it's important to look at the public sector wholeheartedly in this context.
Yeah, it is true. Now, if you look at this IMF definition of corruption, it says abuse of public power for private benefit. So it is, as you said, fingers are pointed at the public sector, but it does not mean the private sector is not corrupt. And also, in addition to that, there may be other acts, other offences related to the corruption. So therefore you cannot, the corruption, taking a bribe, there are bribe takers and bribe givers. So we are dealing with the bribe takers, but there are bribe givers. They are also equally at fault. So the act, whether act adequately deals with that is questionable. These three legal experts would respond, but I feel that it is not adequately addressed.
Very quickly, Mr. Malya, before I move to Piyumi, you wrote a book.
Sorry? Yes, I did. Yeah, I did.
What went wrong?
Yeah, that's right.
So what went wrong in Sri Lanka? Isn't it corruption?
Not only the corruption, it is inefficiency, corruption, lethargy, then also the insensitivity.
So corruption is one main point, isn't it?
Corruption is one, yes, but
So
one
don't
among
you
many
think-
others.
But don't you think that this bill is progressive because of that reason?
Sorry,
Don't you think that this act is progressive because of the reason that there has been corruption rampant in the country for many decades?
yes, exactly. So it is a timely needed thing, no doubt, because even inefficiency is kind of an act
Right.
of corruption.
Right. Thank you very much, Mr. Chandrasena Malya, the former Minister Secretary of the Plan Implementation Ministry of the then government. I now move my attention towards Attorney at Law Piyumi Madhushani, Legal Officer of Transparency International Sri Lanka. What is your take on this act?
Good evening and thank you very much for having me today. I think given the current political and economic context, today's topic is of very much significance because we are in an economic crisis and the country has gone bankrupt. Corruption in Sri Lanka is very systematic and entrenched. Corruption has taken away our resources. Corruption has taken away our opportunities for economic growth. It has taken away our faith in the system and the trust towards the government, as well as our hope for a better future. And people have been demanding for a change in this corrupt system for a while. And in order to achieve that, having a strong anti-corruption legal mechanism is important. And we were in need of a better law. In terms of the new anti-corruption law, there are several progressive provisions. For example, new offences related to bribery and corruption are being introduced, such as private sector bribery and offences related to sports. And also the powers and functions of the Siabok have been increased, and now people can have access to asset declarations of politicians and public officials. This is something that we have been, as TISL, have been campaigning for a while. So while there are such progressive provisions, there are some other provisions that could have been improved further. For example, electoral candidates who fail to submit their asset declarations with the nomination cannot be sanctioned under this new law. And in addition, there are some other aspects which are not covered within the law and also not considered to be part of the law, but which are really important in terms of the anti-corruption mechanism, such as public procurement and asset recovery law. So overall, I think the impact of this new anti-corruption law will depend on its enforcement, overall governance system, as well as the willingness of the government agencies to enact this.
Right. Piyumi, just to get some clarity on this, so is this Anti-Corruption Act going to replace the current Siabok Act asset declaration as well, or is it going to be in addition to the all these acts that are already in place?
So before this new law was coming in, there were three different laws: Bribery Act, Siabok Act, and the law relating to asset declarations.
Right.
So the new anti-corruption law will be repealing these three laws and replacing the same laws, but we can say that it is a it is an updated version
Right.
of those laws.
Right. So I did some research today before I came to the show, Piyumi, and when I read through the newspaper articles that have been published in this regard, my attention was dragged to the 15th of October 2022. The statement that was issued by the Transparency International Sri Lanka. You all say in this report or statement in question, Sri Lanka does not lack laws to deal with bribery and corruption even at present. However, the enforcement of the said laws remain inadequate. So, doesn't that spell out that laws being implemented alone is not sufficient? The implementation itself is what is required, even though any laws are implemented in the country or brought into fruition.
Of course, by this time when it was 2022,
To October 15.
yes, we were part of the drafting process of the law as well. Time to time, we were giving recommendations to the Justice Ministry for improvement of the law, and within the limited time frame given for us, we also opened it up for public consultation. We got some feedback from public and as well as experts in the field, and we forwarded those to the Justice Ministry, and this law comes in with all these inputs as well. And as you correctly mentioned, implementation process in Sri Lanka has always been a problem. One thing is that the drafting process, of course, is always hurried, and when the laws are also passed, the implementation does not take place properly. It could be impacted by several reasons. It could be the lack of willingness of public authorities,
Right.
and it could also be the lack of resources and political influence sometimes. And now, since it's about to be implemented, it's high time that we take this very serious.
Because we've seen laws being implemented. I want to drag your attention to 1987, the 13th Amendment to the Constitution, for an example. This has been part of our Constitution since 1987, but nothing has been done with regard to the 13th Amendment to the Constitution. So do you think that even this bill or act will only be restricted to mere words and not implementation?
Well, on the face of law, this is very progressive, while there are a few loopholes. But if this is enacted and implemented properly, this will of course be
Right.
very progressive.
Right, so we'll talk about the loopholes in a bit. Mr. De Silva is also here today, so we can definitely have a good conversation alongside with Attorney at Law, Mr. Vijay Bandara, as well as Chandrasena Maliadda. So my focus now moves towards Attorney at Law, Mr. J.M. Vijay Bandara.
Yeah, thank you very much for having me today in this worthy discussion. At a glance, if we talk about black letter law, I can say that this piece of law, now it is passed and going to be implemented soon with effect from 15th of this month. It is a progressive law if one going through black letter law. It has consolidated previously existed bribery and corruption laws and other related laws. But it's my major concern that I am going to raise today. These laws were there. If any new piece of legislation come into operation, it should be to cover up existing laws, some loopholes, lacunas, or difficulties, obstacles. But as far as bribery and corruption law prevail prior to these acts are concerned, I don't see any constructive attempt to implement previously existing laws. For example, if last 2-3 years, Bribery Commission has instituted many number of cases, and out of those 69 had been withdrawn. That has nothing to do with the existing law. It is not a wrong of the or loophole or lacuna of the existing law. So that was the attitude in Sri Lankan system of governance with regard to bribery and corruption. Therefore, mere enactment of a law would not do any justice to ensure good governance in Sri Lanka. So let me put it this way, What we are struggling today is lack of good governance. For that purpose, as a lawyer, I divide law into two pieces. One is law applicable to subjects like you and me, traffic laws. Those are very well implemented. And the other area of branch of law is laws applicable to public sector, constitution law, administrative law, and applicable to governance. So in these two branches of law, what is totally disregarded is, for me, the law applicable to governance. Law applicable to governance. For example, we cannot talk bribery and corruption without just and fair elections. Without just and fair elections. We cannot talk bribery and corruption without independence of judiciary. We cannot talk bribery and corruption or eradication of bribery and corruption with a constructive and less time-consuming system of adjudication. So what we are right now faced, maybe IMF wanted to incorporate into Sri Lanka legal system internationally recognized certain concept of to eradicate bribery and corruption. That is there in this black letter law. But what happened when we adopted ICCPR Act? What happened? For what it was used? It was abused in fact, some section. And finally, very recently, High Court has to write a judgment saying that police is wrongly applying this section. So police also part of governance. Police also part of governance. So what we see in Sri Lanka, day to day, those who are involved in governance, they are above the law. That is what we are seeing. Always. Can you say a particular public figure, we cannot say there was no corruption prior to enactment of this act? There were information disseminated throughout the country, so many allegations there, but can you name a particular landmark case or incident that particular person is convicted by these laws? No. I mean, is it wrong of the existing law? Surely no. Is it something wrong with the system of governance? What people are crying today, have in place a proper system of governance where all are accountable. Look at this act, it defines the governance. It says, let me quote, it says, governance include, for the purpose of this act, governance includes system and process that are designed to ensure accountability, transparency, responsiveness, rule of law, stability, and participation of civil society in the administration of government. Without this requirement set in place, whatever law that may pass by parliament will just stagnate just as a back letter piece of law. Nothing would serve to the society. That is my impression at the moment, because I am seriously concerned. Even prior to enactment of this act, there are many cases, complained to Bribery and Corruption Commission. They inquired into, they have instituted certain action. Sometimes necessary number of signatures were not there in the indictment. As a result, the accused has to be discharged. Can you fill those gaps by introducing new act? I don't think so.
Right. So if you look at it very quickly, Mr. Vijay Bandara, don't you think that this piece of legislation that is coming in right now, the Anti-Corruption Act, is a simple box ticking exercise in order to access international funds to the country?
I believe so, because this type of law, I mean any piece of law, this is a very much touching the governance system. You have to have a proper consultative system. Before passing this act, I have to say there was no proper consultative system. It's one gentleman said there are various sectors whom should have been consulted and negotiated prior to identify this. Of course, since it is adopting internationally recognized governance sections, I am not blaming the contents of the act. It may be progressive, but this is purely for the purpose of hurriedly passed legislation to please IMF. Having said that, I have to say, if IMF also relying on this piece of law only, without looking at whether Sri Lanka has successful in placing the governance system proper,
Right.
then their objective also is a concern to me.
Right. Thank you very much, Attorney at Law, Mr. James Vijay Bandara. Again, you can pose your questions to the number 076-656-5353. I would love to take those questions to the panelists as the show goes along. Just please be mindful that we have only an hour today for the show. We have to wrap up the proceedings by 11 p.m. because of the fact that we are also telecasting the match repeats on TV1. Hence, let's get the ball rolling quickly with Niresh today.
Thank you, Shamir. Mr. De Silva, you mentioned that this is a progressive law which is timely, but our country's problem has always been the implementation of the law rather than a lack of laws. So of course laws need to be upgraded once in a way, but if they are not implemented, there's really no point. Now today there was a news item that the chairman of China's largest life insurance company, a state company, had been sentenced to life in prison without parole for corruption. Now, is there any guarantee at all that our new act here would result in such powerful figures in our country being brought to book at all?
It's a very good question because we have a good legislation, but the fact remains, as you quite correctly point out, how are we going to implement? Why so lacking earlier? That is, Mr. Vijay Bandara also concerned about that. My request and my argument would be, why can't you go into this and see whether they have included any progressive thing? Now here, of course, expert witnesses have been included, expert investigated. Now in our bribery commission, we have only police officers where they have not up to the mark to investigate this type of corruption. As you know, the corruption, of course, is a difficult area to investigate into. So that is why they have purposely included experts, that they should be having various areas of expertise. So here 20 years of experience is also included in that, merely because the police officer, they can't have that, and then what will happen is they will sometimes abandon the investigation. That is why they say that what happened to the bribery commission's complaint earlier. Now here, of course, they have purposely included that, and thereafter assets, with regard to assets also, there is a special director board to go into that and then inquire. So those are progressive things, but we have to have expert people inside the bribery commission, otherwise we can't implement it. So if they are going to have that strong case before court, the cases will not fail. That is the main thing. In other criminal cases also, what we say is you have to have proper investigation and put up a good case for the court to go into that, otherwise defense will show that.
But Mr. De Silva, going by, if you look at like real world examples, based on what Niresh was saying, you look at that person being convicted. Shamir also spoke before about high profile cases in Sri Lanka. I think the most recent high profile case that comes to mind, corruption related, involving a big sum of money, is the Silreddy case.
Sorry?
The Silreddy case. Yeah. Where 600 million rupees from the Telecommunications Regulatory Commission's budget was taken to buy Silreddy to be distributed for election campaign. There was a conviction. Both the suspects, the accused, were convicted by the High Court. Then released on bail when it went to appeal. And I have no idea what the current status of it is, but right. The accused who were convicted are going on.
Don't say like that. It was heard, argued, and then the judgment was given because that was not properly constituted case to convict. So the Court of Appeal has given the judgment. So we can't discuss that with regard to the case.
You can, from the layman's perspective, you can observe this and you look, okay, you have this example in China where this person has been involved in, accused of some corruption. You look at the strength of the system in which that person has been punished, the punishment that has been given, which probably matches the severity of the offence committed as well. And then when you come to Sri Lanka's sort of history of cases like this, it's always the same case. It always goes through the same process.
No, that's why I categorically stated that investigation purpose is an important area where we didn't have that. Because those police officers, they couldn't cope up.
So what you're saying, Mr. De Silva, basically is that all of this that all of these people that have gotten off free over these past decades, they've all gotten off free because of failures in the investigation.
That's correct. Perfectly right. Because though they were convicted in some area, at the appeal stage, they were acquitted on the basis that it was not a properly constituted case.
That is quite a glaring indictment of the public sector.
But Nadim, I just want to correct you there because they were found guilty, but through the appeals court, they were acquitted, Anusha Palpita and the President's secretary. So
right.
we should remind our viewers that there was no contention there, because at the end of the day, the appeals court decides, and their verdict on this case was final.
Yeah, and
we need to
what
respect
is saying is that that verdict was prompted by failures in the investigation.
That of course we are not certain.
That we are not certain.
Without going into the content.
I have gone into
then he will answer, yes.
No, I can definitely say
it's due to failures in the investigation.
The appeal court categorically stated that this is not a properly constituted case. So that is why they say investigations were not properly done.
So yeah,
that is why they were acquitted.
On that note, Mr. Malia, I want to say what Mr. De Silva is saying is a very glaring indictment of the capacity and capability of officers in the public sector, officers of the law enforcement officers in the public sector. Do you agree with that? Are our public law enforcement officers so incapable that they...
Well, I won't say so incapable, but not capable enough.
That's correct.
Yeah,
Capable enough.
Yeah, because you know that sometimes they are capable enough, but they don't act. They don't. There is no decision made. When the decision is made, it is not carried on. It is not implemented, and then there are capacity problems. But also there are other issues. Now, if you take, there are certain acts, archaic laws in the country. The Forest Conservation Act was passed in 1907. The Fauna and Flora Act was passed in 1938. UGC Act was in 1978. The BOI Act is 1978. Yeah, more than or nearly half a century old, and world is moving fast.
So what you're saying is our bureaucracy is mired in the past and is not...
Yeah, your bureaucracy is not changing according to the trends in the country, as well as the needs of the country, as well as...
So Mr. Malia, do you feel that now the question that we're asking today is this Anti-Corruption Act an eyewash, or is it actually going to achieve something?
No.
So let me ask you this question. Do you feel that now that this legislation has been passed and from the 15th of next month it's coming into force?
This month.
Sorry, from this month it's coming into force. Are you confident that this act will help build the capacity of the public sector, will help build the capacity of these officers?
No, I don't think, because this is only a reactive process, not a proactive process. So now, if you look at this act, the purpose say two purposes. One is to detect and investigate allegations of bribery, corruption and offences related to the declaration of assets and liabilities and associated offences. That is one. The other purpose is to promote and advance the prevention of corrupt practices, to educate and raise awareness among the public. So there are also 10 objects. 5 are on prevention. But if you read this, there are 164 clauses, only one is talking of the prevention. So prevention is very important.
So again, this seems to have been very much a rushed legal instrument here. Although of course the UN Convention is from The UN Convention Against Corruption is from 2003. For nearly 2 decades, we have ignored it.
Actually,
And then
Girish,
at
we
the-
haven't ignored it, because when the 19th Amendment was brought in, the UN Convention Against Corruption was included and it was given constitutional recognition. And then after Gotabaya Rajapaksa was elected president, through the 20th Amendment, they stripped all of those clauses. So we actually went backwards.
Yeah. You know, the issue is, now we have enough laws, regulations, institutions. There are procurement commissions, procurement acts, all that are there. And also we are the only country we establish a good governance government. So but with all that, corruption also coexists. And that is, we don't take action to prevent from
So it seems to me
Yeah.
that it's not a problem of the bribe giver and the bribe taker, it is a problem of the implementer of these laws. And
course.
there is nothing in this new law which would force the implementers to implement the law.
No, you can't say like that, because that is why I categorically stated that there are expertise in this particular act itself. They say now their bribery commission will get in those people into their commission, and then they will be given the opportunity to handle those things. Then only we can see. If you are seeing it in negative way, always think that it is not going to do anything. But no, don't do that. This is a good state where we expected this to happen, but at the moment we can't predict. It's premature. Now what they have done is they have included those people, and then if they are not working properly, they will throw out. The parliament can throw about. That is the very reason that they have given opportunity. Every 4 months they have to report to the parliament with regard to their progress. Then the people can see what's happening. Earlier it was not there. That is why I say.
But don't you think?
Mr.
But
Dissilva, the
let
Bribery
me-
Commission already, like almost every, I think half yearly now, they put out their reports.
1994 onwards they are doing it.
They've been putting out their reports. And when you look at the reports as well, it's there's this terminology that's used in civil society circles called grand corruption, which refers to corruption where the value is in excess of a certain amount of money. But you look at all of the cases that have been successfully prosecuted by the Bribery Commission are all almost petty crimes.
Yes.
Right? A police sergeant has taken a bribe of 25,000 rupees.
A school teacher.
School teacher, school principal or zonal education director or someone took a bribe of 150 or 200,000 rupees to put someone's child in a school. These are the kinds of cases. There have been some cases with forest conservation officers, etc. And it's all usually bribery and very small level cases. All of the big ones, and maybe it's because, like you say, they don't have the capacity to carry out these investigations, but in all of the cases which are basically where you would term it grand corruption, there has been no successful conviction, let's say, where the person is convicted, they go through the legal process and they are either locked away or have been made to pay a massive fine.
And what is the
this is
public-
why I find it very concerning that, true, it's good, and as you say, there are progressive elements in this law, and having read it, we will also say, okay, this is very progressive, this is a step forward, we should do this. But if it is not implemented, then it will just be like giving constitutional recognition to the Convention Against Corruption, because it didn't achieve anything.
I quite correctly agree with you, but at the moment we can't say so, because now after 15th only we can see what is going to happen. So that the commission should be appointed. Now earlier President appointed these things. Now Constitutional Council. Now my learned friend stated that the signatures of those indictments. Now it has been done away. Now it has been given to the Director General. So he signs it, and he was there. Right? He is the person who is there. But Director General also being appointed by the Constitutional Council. So those are progressive things. Right. And 6 bribes. 6 bribes have been identified clearly, and they stated like that. And whistleblowers also. Now earlier there are people who came out and given bogus information. So they can't proceed with that. So to deal with that, they have included some section where if you are going to give some information, and after the inquiry you find whether they are wait just a minute. If the bribery commission finds that those are purposely, jealously put forward the complaint, then they will be tried before the High Court.
So Piyumi, you said that there are loopholes in this act in question. What are those loopholes?
Yes, there are a couple of loopholes. One would be the one I previously said. The electoral candidates are required to submit their asset declarations along with their nominations to the election commissioner, and failing to do so will be an offence, but there are no sanctions for it, while there are sanctions for other failures of other officials.
Right, so with your permission, let me just ask Mr. De Silva, there is one loophole that Piyumi spoke about. Has that been addressed in the act?
Only thing is, now they have stated every person should come forward with their asset declaration, even the president or the other
what are the sanctions that are
that's what I'm telling
going
you.
to be there?
Now, with regard to that, that's a good question, but the only thing is it can be covered by the election commissioners. There is a special act for that. That can be implemented.
So just give me a second. So one loophole you identified, and we had an answer from Mr. Silva. So what are the second and third? Just so we'll ask. After you mention the loophole, I'm going to probably direct that to Mr. Vijay Bandar or Mr. Maliad or Mr. De Silva to get an answer to see whether this has been addressed.
Yes. Before that, I would respectfully disagree with the statement he made, because it says election laws will be covering it, but for the moment there's no proper law in terms of the sanctions to cover in election related laws as well. And another loophole would be, this was commented by us for several times as well, 119, where it says complainants who makes false allegations against anyone and who will make allegations knowing that he or she has not committed an offence relating to bribery and corruption can be convicted by this law. So we were informed by the CBOG that this has of course been in the previous law as well, but this was not used against anyone, and we do not see a point if it has not been used so far. We also do not find a reason to keep it, because we have a history of using good laws to take revenge from people, and in a bad way. So this can be used against anyone who is willing to reveal corruption and complain against corruption.
What's the other point?
And also,
excuse me. Now, is it not there? It is there to go and prosecute the people who are going there and false allegations had been made, and after that it is found that it's a false allegation, then they can be charged. It's there. But with regard to sentence, they discussed to bring down the sentence. They were not happy with the excessive sentence. But anyhow, it is there. But whether they are going to implement is the
problem. A big question mark. Right.
Our argument would be that it would discourage people who are willing to come forward and report corruption.
No, I don't think.
And especially,
I am
especially when
evenly
especially when we take into past experience, these things popped up when people are in opposition, charges and all this. When they are in government, what we have seen is withdrawal. Bribery and corruption. Nobody can deny. Please, if you give me any example where bribery and corruption commission during last 2-3 years withdrawn, mainly I am talking about politicians because they are connected with bribery and corruption. Any opposition members case withdrawn?
No, I don't think Mr. Vijay Bandar, you are correct in this position, because it's a
no, let me finish this.
It's a fact that it has been withdrawn.
I want to raise a point. Let me. So then, in that circumstances, we have experience, as she correctly said, how ICCP are used against innocent people, even artists. They were remanded.
I mean, we've seen that in the past.
We have seen. So then, what is the assurance that they will not revenge from the genuine people who have complained against the rulers, right? And then this reporting process is a very vital fact. Reporting process, they say report to Parliament. Indirectly, Parliament take over supervision over the bribery commission. even after the new act come into operation. Who are in parliament? Members of parliament, cabinet of ministers, prime minister, all are in parliament, and they are running the ministries. Those are the institutions that will be targeted.
So there's a question on that. Let me pose a question to Mr. De Silva on that. We have a viewer asking, Section 42 says the Commission can initiate investigations, which means on its own initiative. Does this mean an allegation in the media can be taken up for investigation? However, could be thwarted if the allegation is made under the guise of parliamentary privilege, especially when its contents of the report is based on Hansard report or documents tabled in Parliament. Any comments on this?
Yes. Only thing is the bribery commission was given the power to investigate into without waiting a complaint. If they come to know some sort of corruption or allegation about bribery, they can go into that and then they can inquire into. That's a fact. So whether it's a perfect thing or not is the thing, that whether they are doing it properly or not. We merely because it is stated there, we can't say it is not good. It is there because it is important to have that type of a thing. Otherwise, we are waiting for the people to come and lodge complaints. So if they come to know by way of this paper advertisement or paper report or television report, then they can call those reporters and ask recorded a statement and proceed with that. So that's a
so Mr. De Silva, this was there under the 19th Amendment, where the Bribery Commission was given the power to initiate investigations on their own. So about a year after the 19th Amendment was passed, we submitted an RTI application to the Bribery Commission and we asked them, how many such investigations have you undertaken? We didn't even ask for the nature of the investigations. We just asked, how many such investigations have you undertaken? Zero. So
that
a year after that.
That is why I say, so we can't say actually what happened there.
Right.
Inside the Bribery Commission, there were a lot of problems with regard to conducting of investigation. So they needed some people to have that expert.
So are you trying to say, Mr. Silva, that there are no expertise at the Bribery Commission right now?
Yes.
There are no.
There were no, because only, I don't want to blame anybody. Some normal police officers, if they were interviewed and if they say that they are ready to work with the Bribery Department, that's all. There are no qualification. Here, of course, they are specifically mentioned about the qualification. So without those qualifications, they can't.
So how long will this implementation process take? Now say there are qualifications that have been articulated, all that is good and well and good. But when will it be implemented?
It should be done immediately, because now once the commission is enacted after the 15th, they will go into the operation. So then they will recruit people.
Right. So Mr. Malyada, we have a question from one of our viewers again to the point that you made with regard to the public sector being targeted in this act in question. The main culprits for corruption are parliamentarians who get those close to them to commit the crimes. The people so involved down the line do it at the cost of losing their lives if they betray those telling them to do it. How will the act address this problem?
No, I don't think you can isolate one group and say they are corrupt. There are corrupt people in all the sectors. Now, if you look at the public sector, the politician, the academics, the professionals, lawyers, the private sector, there are corrupt people and corrupt acts. So what happens is that we are not taking any action to prevent. Our laws are not sufficient. This act is not sufficient. So we allow them to happen and then do post-mortem. So that is where we go wrong. Now if you look at this chapter 4, powers and functions of the commission, it runs into 48 pages. And if you look at that, I don't think the Director General can take up more than one case. The procedures, the steps to be taken, it's a long, lengthy process, It will take ages.
That boils down to the point that Mr. Vijay Bandara made before. Have a free and fair election, the independent judiciary, and then the adjudications in terms of cases. So there is a big question mark.
And also, you see this now, Mr. De Silva and me and we all agree, bribery and corruption are crimes. There is no dispute regarding that. No? Now, under our general law of criminal investigation, criminal procedure, there is no process of reporting to Parliament. It is within the established criminal justice system, Attorney General Department, Criminal Investigation Department, and various, there is a particular system set up. But here, we all know that bribery and corruption mainly deal with politicians and public sector. Now, when dealing with that, they have introduced this criminal investigation to be reported to Parliament.
So what's the point of reporting to Parliament where there is
indirectly
a
placing
gold
under
smuggler sitting in Parliament,
exactly,
and the other
so
Parliament
indirectly what will happen? Commission will be under the Parliament.
No, that's not correct. Because
this is very unfortunate situation.
Earlier it was independent. Nobody can query. Nobody can get all the
Parliament itself not independent.
So that's the issue there. They were asking why bribery commission was silent. They are not coming.
But this is what Niresh was trying to refer is, we have parliamentarians who have smuggled gold and who are sitting in Parliament. Then we have, right now we all know there is a health crisis in the country, and we see no confidence motions being tabled in Parliament, and how health ministers go scot-free with the problems that are faced. So there is a big question mark right now in terms of the actions of even the parliamentarians, isn't it?
Extortion convicted people, murder convicted people.
Because people say 225 all are corrupted, that's wrong. Mr. Maliyadda quite correctly pointed out, they are. But the fact remains, the other important factor would be, how can the people know if they are not being reported, if they are not asked to report to the Parliament?
Right.
They are not under Parliament. They have their independence, but they can't say we are not bound to give any information to the public.
Now the question mark is, Mr. Silva, if you look at the past, we've seen the Financial Crimes Division that was set up. The Bribery and Corruption Commission was involved, the Attorney General's Department was involved, the Police Department was dedicated to having FCIDB, saw how high-level individuals who were corrupt could have been arrested and brought to book between 2015 and 2019, but it never happened. So what assurance do we have that such an act is going to do justice to the people of Sri Lanka?
So that is why they say it is an independent body where they only report in the sense that they will divulge what is the progress, that's all. The Parliament can't dictate you do this and that. Why you all have not done is the issue there. As you quite correctly asked me, they can ask why you are not doing that particular file, you have ignored it. Why is that? That can be done, it should be done.
But don't you think that is already happening at the COPE?
No, that's not correct. Only the Pope doesn't have any implementing thing.
That's just a public gimmick.
They call the people and they ask the TV to come there, and then they will question, that's all. That's the end of the matter. They will not inform the speaker to take action or to report to the Attorney General. Then only we can implement it.
So this is just for some clarity. So the Bribery Commission will be reporting to a specific committee in Parliament, or
No, generally Parliament.
to the
General
Speaker?
Parliament.
So basically, it will be submitting its reports to the Speaker.
Report is
Right.
the
So
purpose
now
of knowing that.
they put this in writing now in the Anti-Corruption Act, saying that you must report to Parliament. Anyway, their reports were public.
Yes.
No,
Anyway, they are
it's
by
not correct.
by half yearly and annual
Cases
reports.
are
report, we
heard
can't
in
see
public.
that because only
You can't see
if they-
specifics, but the general report is public.
No,
you can get
what
it
is
from
the
the
general
Reserve Bank
report?
website.
You say only
Annual
when
report.
the indictment or charge sheet is come there, only we can see.
Why should
Otherwise,
people know the investigation? I mean, for example, if minister or member of Parliament is a suspect, and you report to Parliament, then they have the access. The suspect have the access to the
that is not
investigation
correct.
information.
This is unnecessary, going beyond the limits of that. They are reporting in the
Sir,
same.
first of all, we have to respect everyone's opinion.
That's what. Now he is taking only up to some point. We have to adhere to that.
Now you
Because-
seem to be taking the government's point of view.
No,
Mr.
not the
Bhatta seems
government.
to be taking the opposition
I
point of view.
am
So we'll respect
concerned about the
everyone's
act
opinion.
only. I am not saying anything with regard to the government. Whether they are genuine or not is a different issue. We have to discuss later on that.
So they are not genuine?
No, not another day. Another day.
They are not genuine.
No, there are people not genuine.
Not genuine.
Oh, yes,
In the government?
In the government itself.
Who, Mr. Silva?
We can't discuss this matter. This is anti-corruption. So we are discussing about the
Right.
anti-corruption.
So-
The
so
only thing is,
yeah.
what I am saying is, we have to very clear about that they will only say what is the program, what
Mr.
step
Sir, you're
they have
saying you're
taken.
not on the government side, then you're saying people are corrupt. When I ask you who the people are corrupt, then you don't say who the people are.
No, this is not the Shamil, you must give me the opportunity to explain this.
I'm giving you an opportunity to tell the
That
name.
is why I'm saying Parliament is not bound to dictate them. What they say
And
is
because
you
of
can
that, this is an
question-
eyewash.
They can they can question them and ask why the opposition is there. No, the Andrew Kumar always asks several questions inside the Parliament, so they can ask from the bribery department why you have not done. I have given several files, so I show the files and say that I have given you the file. You have not taken any action. So that question can be put to the bribery department at that point. Every 4 months they have to come to Parliament and report. That's all.
ඒ ඔක්කොම යාළුවෝ. Mr. Sir.
That's a different matter. So I don't want to comment
something
on
called
those.
Sinhala Horaage අම්මගෙන් පේන අහනවා. If you
I don't
report
know
to
who
same
is
thing to
Ora and who is
Parliament,
Amma. I don't want to comment on those things. But the fact remains, we have to respect the Parliament. This is Parliament proceedings are there.
Respect
So
must be earned.
we must respect. By appointing various people, and now we are blaming them.
Yeah, so,
But Mr. Vijayabandra, if it's not the people's representatives who are going to oversee the bribery commission, who should have that power then?
no, it should be independent commission mean, for example, if
But there has to be some oversight, right? And
Yes,
that oversight should
oversight.
ideally come from public representatives.
so, I mean, without providing reporting system, it can be always raised in Parliament. Now, what is the obstacle?
But it's not happening, right? Maybe
It's not
maybe what
happening,
should be
that's
done is a better this thing where you have a specific
the
committee on
entire-
law enforcement which will be then entrusted with supervising these guys.
If it is placing supervising power with the Parliament, especially
No,
But
not
that is
supervising,
one of
that's wrong
that oversight.
word.
That
Wrong word.
oversight. That
Only
oversight
reporting,
power
only
of
reporting.
Parliament is one of the two key functions of Parliament. Not just the Sri Lankan Parliament or parliaments worldwide, legislation, and the second is oversight.
So this kind of sometime executive action, the investigation is a former executive branch of the investigation. It is cannot be coupled with the
but the
legislature.
executive is overseen by Parliament. That is the, I mean,
No,
in separation of powers,
separation of
that is
powers,
the,
say
that is
executive and
the executive must be overseen by the legislature, right? So, because if you're saying that the bribery commission doesn't need to report, Parliament may have its flaws,
Yes.
right? But what I'm saying is, I think the point that Mr. De Silva is also trying to make is, if not Parliament, then who? Because otherwise you're looking at what basically a authoritarian system of.
No. In any system, if then take for example, police department must not report in Parliament. But do you say that criminal investigation are not taking place?
But they should.
Criminal litigations are not taking place. These are criminal in nature. So then if criminal investigations are not reported to Parliament, why only bribery and corruption? Especially when
But shouldn't the police department, the attorney general's department, the entire
Yes.
law enforcement system, the
Yes.
entire criminal justice system, shouldn't it be, when you say, I think accountable might be a strong word, but shouldn't Parliament have a degree of oversight?
So it is there right now, no, without any reporting system. Right now it is there, no.
But it is.
Why
Are you
specific
satisfied with where it is?
Yes,
right
and if
now?
Parliament want to raise any voice regarding anything happening, Parliament powers and privilege, and also they have the forum. They can question anything without specifically providing for reporting system.
Right, so Piyumi, now President Ranil Wickremesinghe promised with the introduction of the Anti-Corruption Act will include the stolen assets recovery in line with the World Bank as well as the United Nations. Do you think that the proposed bill have sufficient laws to ensure that recovering stolen assets would be the primary objective of it?
Well, CBOC is given enough and more powers to inquire, investigate and prosecute on grand corruption as well. For example, it is given the power to do joint investigations with the other authorities and agencies who are doing similar kind of investigations, and it is also given the power to coordinate and cooperate with the international agencies. But I would say there is a need of a comprehensive law on asset recovery, and as we heard, the law is in the making and it should be out.
See, again, this is my issue. So now these laws have already been drafted. There was the Proceeds of Crime Bill that was being introduced. There was the Stolen Asset Recovery Initiative that was functioning under the Presidential Secretary. I think Attorney at President's Council, Valiamuna, was heading that initiative, if I'm not mistaken. So basically, what we're doing now is, because the discussion is whether this is an eyewash, so we're asking the question whether are we just reinstating the pre-existing system of the 19th Amendment because it was taken away on the 20th, and then we're hoping that by some miracle it will all be implemented.
What I am interested to know is, under this new act, are we going to see any cabinet minister arrested from previous or present government?
You can see that. You will.
Mr. Silva, you came on this very show. I remember you came on this very show before when the 20th
Amendment, exactly. I also say yes.
The 20th Amendment
assured that it will be a good piece of law.
President Rajapaksa won't be contesting.
Yes.
And he won't become the Minister of Finance.
Exactly.
You were sure?
Yes, assured.
You were sure that he won't be appointed? No, you didn't say assured. No, sorry. You said appointed. Under the
he asked me not to be negative.
And now you're saying
that how can I read his mind? I was going on the basis
So
of the
today also
reports
same.
available. So I believe.
You're the only one who didn't read his mind. So all of us read his mind.
Yeah.
All of us knew that he's going to
I don't have that. I don't have that. Read that mind of that, specifically Basil Rajapaksa.
Yeah, but you don't have to have a crystal ball in front of you to decide that.
I don't have that. So
No, you don't have
I
to
don't
have a
want to
crystal
say
ball.
anything. But going on the basis of the reports available, I came out with that story. But they didn't do that. That is why the Gotabaya Rajapaksa also left, because he has not done anything that he has promised. So that why can't you say
Mr. Malayada, now,
regard to that?
Mr. Malayada, when we discuss about what went wrong in Sri Lanka, you spoke about how corruption played a role in this entire process. In your opinion, do you think that we are bringing in these laws just as an eyewash, just to impress the IMF right now?
No, I don't say so. You know now, anti-corruption bill is there, the bribery commission is there, so they are expected to do a role. But it does not mean that we can go on committing corrupt acts, and it does not mean that we should keep our eyes closed. Now, being a secretary to a ministry, I am the chief accounting officer. I am accountable and responsible for the public funds. So if I keep my eyes closed as the secretary and expect the bribery commission or the anti-corruption people to come and take action, that will not happen. Each one of us has some kind of responsibility. We neglect it, we don't discharge it, and then we expect some higher superior body to come and investigate and take action. This is what happens. Now if you look at the COPE, there are Auditor General and the COPE has revealed there are so many corruption activities which could have been prevented and nip in the bud, but you allow it. And then then you think, okay, now there are, I can remember, there have been certain decisions, some management decisions, administrative decisions were made by the courts, and then the public sector people question that. But what happens? We don't make decisions, we don't manage. Then it goes to the courts, and the courts make the management decision. So our lethargy, our inaction also amounts to sort of promoting corruption. So I think we all must take the responsibility, we all must take the share of the responsibility and do our role.
Yeah, but don't you think, Mr. Malayada, Sri Lanka is the first country in Asia to undergo an IMF governance diagnostic under global lenders' key structural reform to address corruption, vulnerabilities and enhance growth?
Yes.
So when you look at this, it seems like all these actions are being taken because of the IMF. I am aware through the grapevine that an IMF delegation is due in Sri Lanka tomorrow to discuss about all this and more. So they're doing this just one day ahead of the IMF delegation's visit.
And at one thing, there is sometimes certain thing President went and said, do it before Saturday. Address in the parliament. Do it before.
So it's very evident, isn't it?
No,
that all this is aimed at IMF getting some money in, making sure that just marking the checklist.
Yeah, but now if you look at the scenario, we have been a prosperous model economy in 1948, and over 75 years we have become a bankrupt beginning economy. So then we are trying to get hold of a straw. So IMF is the only thing we can see. So then you know
the issue there is, and I'd actually like to pose this to Ms. Madhushani. Now we're talking about the trouble with undertaking anti-corruption reform as an IMF box-ticking exercise is that I'm sure you know that Transparency International, the Secretariat in Berlin, puts together this corruption perceptions index every year, and every year all of the countries that rank at the top, that as the least corrupt nations, also rank at the very bottom when it comes to the Tax Justice Network's index of corporate tax havenry and financial secrecy. So Singapore, the United Arab Emirates, etc. So now the Tax Justice Network, their estimate of what Sri Lanka is losing in tax revenue that is going overseas annually is $413 million annually that we're losing in tax revenue to money which is basically being parked in these countries, which a lot of which also happen to be OECD countries as well. Now the IMF, while asking us to sort of do this kind of governance reform, which is a good thing if the outcomes are achieved and it's enforced, but at the same time the IMF is also twisting Sri Lanka's arm to implement a OECD approved tax policy that many OECD member nations also are not going to impose themselves. So they'll be limiting our revenue collection capacity. So my worry now is, like, on the one hand we are talking about stolen assets, and the bulk of our stolen assets, you can see it here, is basically a lot of tax avoidance and tax evasion that is happening. By letting the IMF be the driving force of anti-corruption reform in Sri Lanka, are we then bringing in this Eyewash Anti-Corruption Act, while on the other hand we're opening the doors wide open for corporate tax abuse?
Well, we can't be too judgmental about the government's motivation behind bringing this law, but we know for a fact that it is one of the requirement of IMF. And
no,
if
I'm
we
not
are
questioning the government's motivation. I think that the government has no choice but to work with the IMF. I'm questioning the IMF's motivation and the fact that the IMF is now doing this government diagnostic
and
report.
if we are doing it just to tick off the box, we are heading towards nowhere, because it's not sustainable. If we really want to achieve economic stability, and if we want to attract investments and international reputation, we also need to focus on our commitment for the enforcement process as well, because it actually shows the government's dedication towards good governance.
But this word international reputation is a problem, right? Because you're talking about international reputation, and let's say that
and there is
the
another
TI Secretariat,
concern.
they look at these countries that are reputable, and those countries that are reputable are actually the destinations of the stolen assets.
Another
from
concern, if
the
government officially declared before the Supreme Court, they don't have funds to conduct the election. If that is the stance of the government, to implement this act, there may be so many infrastructural facilities and expertise has to be appointed. The government doesn't have funds to have election. That is a fundamental right of the people. Can you expect, even can you predict, they will implement this act after 15?
Yeah.
Giving all the infrastructural facilities, experts and appointments?
So Mr. Disera, let's look at the past. Let's look at the past in Sri Lanka. We've had laws. We spoke about the Seaback Act, we spoke about the Asset Declaration Act, as well as the Bribery Act. Tell me one instance. Now we know corruption is a big problem in Sri Lanka. Do you agree with that,
Yes.
Mr. Disera? Right, okay. Tell me one VVIP in Sri Lanka who has been punished over the last, since 1977.
The only thing is,
No, Mr. Disera, I'm just asking.
no,
There's no one, right?
I don't have all the details.
No, we don't have anyone.
But no, only thing is, if you think so, then I can't say no, because I don't have that material with me. Anyhow, if the cases are being failed at the court stage, then what is the outcome? The implementing process, and then how the investigations are being done. That is why I am always on that point, that we must have that commitment. As she quite correctly pointed out, we have the capacity now, we have all the material with us now in that particular act. We can't say it is not there now, we can't do it. But if we are going to adhere to that, our commitment is there, then we can say that a lot of
Mr. De
people
Silva,
can be.
This, Mr. De Silva, could be the turning point for even the Ranil Wickremesinghe government. Do you know why, Mr. De Silva? Because he can bring back what we lost in terms of the central bank bond controversy as well in 2015. He can probably ask Arjun Mahendra to come, appear before court.
Mahendran appearing in court is a different issue, but the case is being collapsed. Why? They have not properly investigated and put forward the case to the High Court. That is why the judges have stated that this is not a case where we can proceed with that. Without calling the defense, they acquitted the people. So why is that? Why is that? The implemented or the investigation process was not done correct. Whether they have purposely done it or not is a different issue. Shamil, I don't
But
want
normal
to
cases are not collapsed like that.
No,
normal layman's as surgeon, teachers, cases not collapsed.
Though they say 1,000.
Those are simple cases.
But the investigation
straightforward
is efficient.
They go
in
and
that
they
line.
apprehend. The corruption matters, of course, it will have a lot of investigation.
But the problem is, Mr. Silva, what sort of guarantee do the general public in Sri Lanka have that this law will be enacted against VVIPs, against ministers,
Implemented, yeah.
against parliamentarians, and will we see light end of the tunnel? Now that's the question people are asking. It's not about having a law, and you're saying here very nicely that implementation is important. Implementation is important. The question is,
we have to see that.
The question is, will this be implemented?
That is, of course, whether the people who are being appointed to the bribery commission are working on it or not is the issue. Whether the investigators are doing a proper job or not is the issue. So that is why the parliament has been given the power to ask questions whether you all are
But
doing it
even
properly.
right now, Mr. Silva, under COPE, the parliament is asking questions.
But there
We
is
have
no,
seen
no
Charita Hera
implementing.
doing-
So only thing is
doing
they can't
his
go
numbers. We
further.
have seen
There is
that.
no provision for them to go further. That is why we say this act can be done. Now these questions being asked, and then all the material can be put forward to the bribery commission
But
to
if
investigate.
you look at it, Mr. De Silva, Vijayasa Rajapaksa, he was a co-op committee chairman at one point. He revealed a lot of corrupt activities
Right.
in parliament.
He's the first person who came out with
Absolutely.
corruption. Yeah.
Yes, then we saw the manner in which South Surin Handunati played a role in terms of the co-op committee chairman, and he brought in a lot of issues as well. Then we saw WDG Seniratna, when he was the co-op committee chairman.
Nothing had happened.
No, nothing has happened. One day before the co-op committee report was supposed to be published, they dissolved parliament.
At least the express pearl 250 bribe or something with the honorable minister himself disclosed into parliament. Can that be investigated after 15?
Yeah, that can be done.
Has
No,
After the commission is appointed after 15, we can see, we can ask
What
from the
assurance? What assurance do
At
we
least
have Mr.
about
Silva?
that
Yeah,
one
what
single
assurance do
assurance?
we have that after 1 year you will sit on the same show and say, what
Nothing
can I
happened,
do?
nothing
has happened because officials were not appointed to the bribery commission because there are no competent people.
So
to do that.
if there are no competent people, how can I expect
So that
them to do
means
that?
this is an eyewash.
Huh? No, that is not the case. The parliament can question from the government. You all have not done, and as he said, now you all have stated that you don't have money to have the election. I am not in agreement with that because this is not the election where people
but
can change the government.
No, our point is, when you have in government a resounding majority, how effective is that going to be until the election is held in the country? Don't you think right now the most important point is to have an election in the country and to ask the public as to who they want them to be governed?
So then you expect the people who come over there to next government, then they will implement this. That is why you are concerned.
No, the concern,
we
Mr. De
can't-
Silva, is
we
that-
have, it is our duty to appoint necessary people to the parliament. That is our duty. We have failed on that. So
We cannot exercise duty, no election.
No, I think
They
he's
are
saying they
talking
failed
about
thus far.
election in the sense, what is the election they were talking? That is the election that can not.
Which election? Which election?
They were talking about.
I didn't mention any particular election.
Election every time they are talking
Hypothetical.
about election. Firstly, they started what election? So that particular election cannot change the government. No. At the moment, we can have parliament election. Are you also in agreement
Right.
with that?
So I want
we have to have the
just-
parliament
No, but
election.
do you have any
That's
questions?
correct.
Any election is
Yeah.
important.
No, election is important. I quite appreciate that. But with this country situation, that type of a election, that government
Local government.
cannot be changed. So that is why if the parliament election and the presidential election, it's a mandatory thing. So we have to find money and do that. So it's a people's right. If they want, they can change it. They are, of course, earlier, they cannot change anybody.
Have you got money to implement this act after 15th of September
They
2023?
will provide. Now the country is progressing. We have money.
So have an election.
Have the election.
They will do that. They will do that.
Nilesh, do you have any questions?
They-
One last question to Pumi. Now, in this whole exercise, the biggest stakeholders are the public, because the public has to come forward with confidence and report these crimes, corruption, bribery, all that. But has the buy-in of the public been obtained on this, with it being rushed like this? Why should the public feel any more confident of this Anti-Corruption Act than of the Seabok legislation from 1994-95?
Can I actually just add a sentence to that? In 2015, when the good governance came in, they actually had a public mandate through election, a public mandate to implement anti-corruption measures, which have not yielded results. This government has no public mandate, and it is still undertaking reforms without a public buy-in.
Good.
What is the guarantee that we have that this is not end up being an eyewash?
As a matter of fact, the
Yes, there's public
1994
mandate.
government also
had a
campaigned just
with a
like that.
mandate.
Yeah.
And it didn't.
there
Chandra
was
Bandar and
much,
Khatun government.
much fanfare that
Mr. Maled
that
must be remembering, no?
Yeah.
You were the secretary
Biggest
at that time.
mandate.
That was when the initial act was passed.
Can we have Pumi's views on the buy-in of the public here?
Yes, of course. With the new anti-corruption law, we can consider Seabok as one of the most powerful independent commissions in Sri Lanka, and all the definitions given in relation to offences can cover corruption in political sector as well as public sector, and bribery in private sector as well. So in terms of citizens, I think burden is mostly on Seabok. It depends on the readiness of the Seabok to proactively investigate and also apply this law effectively and equally. And then there's a burden on the government as well to create the enabling environment for Seabok to act independently by providing enough resources financially as well as in terms of human resources. And then civil society and citizens can also play a crucial role in monitoring the enforcement as well. As I said, there are a couple of loopholes in the law that might discourage people to come forward, but there are other laws that protect victims and witnesses of bribery and corruption and other crimes. So people always should take a step to report corruption and voice against corruption.
Right. So I want to give Mr. Vijay Bandara, Mr. Maled as well as Mr. Silva a minute each for your closing remarks as well, because we just heard based on the question that was posed to Pumi, you had a very good closing stand on the subject tonight. So Mr. Vijay Bandara, what are your thoughts in conclusion?
My concerns, what is mainly lacking in Sri Lanka and what is the root cause for this corruption, failure to eradicate or control corruption, is lack of exemplary governance. That is what we are lacking. For that, one is free and fair election is a must. Then this existing system for last 75 years, we didn't see any exemplary governance. That is the root cause that we are right now facing. Therefore, in future, having backletter law is progressive, good, but to implement those laws, what is foremost important factor is allow the people to use their franchise as a fundamental right, and allow people to elect a government, and also system change means exemplary governance. Exemplary governance. If particular president or cabinet minister doesn't have any interest, or if they are not running business personally while having the post, this system will come good and those laws could be implemented.
Right. Mr. Malad, what are your closing thoughts?
No, we wanted the anti-corruption bill is a progressive movement, no doubt. But whether it's adequate is the question. If you look at the magnitude of corruption and the frequency and also where it is happening, the anti-corruption bill may not be sufficient to combat all that. The other thing is, now if you look at this act, the clause 111, clause 162 is given the interpretation. So it gives the interpretation of bribery gratification, but no interpretation given to corruption. So I do not know what you mean by corruption, because this, according to this act, there is no interpretation given to corruption. The other thing is, that the implementation of whatever it is, the laws, the decisions made in this country is very poor, very slow and time taking, and the certain procedures and processes are too lengthy, too cumbersome, too complicated. Now, even if you look at the process of the investigation of the provided in the Anti-Corruption Act, is a lengthy process. So it will take ages to investigate one and conclude. So my final word is that, after all, the taste of the pudding is in its eating.
Thank you very much. Now I move to Mr. De Silva.
Yeah, Shamil, now I am thankful to you all because you are the people who are discussing these matters at length in this type of a conference or face the nation. We are talking about these things with regard to this forum because you all have given us an opportunity. Now, with regard to this act, I say it's to some extent we are happy, we have to go forward, and to do that we know the anti-corruption, if you are going with the anti-corruption things, there may be 5 principles that is called trust, T for top level commitment, and R for risk assessment, U for understandable control measures, and the S for systematic review, and T for training and communication. So if those things are there and the attitudes are changed, can be changed, then of course we can go forward. So what Mr. Maliat, they always say, preventive active. So we are not concerned about that. We are going only to implement these particular areas, but without giving the opportunity to people, or without educating them what are the corruption and what is the bribery and how we are going forward with that, and then how to eradicate those things is the issue. So if we go positively, then we can get results on that. You may have a lot of programs in future when the act is being
So keep your dates free next year. Same time I'm going to invite.
Same day.
Yes. Not the same day.
Same day. No, we can't say no.
Or Thursday.
So
but
during this time,
during this time, I'm going to call you and then I'm going to ask you the same question that I asked when Basil Rajapaksa was appointed as the Minister of Finance.
And Mr. De Silva has promised us that under this act we will see some top level people arrested and charged.
They have now after this act, they will not commit this type of offences. That's a big.
He is like Sri Lanka Mata. He never changed his stance when various government, prime ministers, cabinet ministers all change, but he always represents that side.
So
What side? Which side?
Tomorrow onward, we will have a lot of work for next year.
I always with the government. Yeah. Any government, if the government is there, we have to represent the government. I am working with the government because it is our duty to go forward. If they are going wrong way, we say it's wrong. That's why we are here. That's why you are asking me to come here also.
Thank you very much, Mr. De Silva, President's Counsel. It's always a pleasure to have you on board.
Thank you.
Mr. Chandrasena Malia, the former Ministry Secretary of Plan Implementation, Attorney at Law P.V. Madhushani, Legal Officer of Transparency International Sri Lanka, Attorney at Law J. Mujay Bandara. Thank you very much, gentlemen and the lady, for joining us this evening on Face the Nation. Thank you very much, Nadim. Thank you very much, Niresh Eliathambi, for joining us on Face the Nation tonight. For those who send us their questions, 07665655353 on that number, thank you very much as well, and thank you very much for connecting and watching us. We would have loved to at least grill the panelists for another 20 to 30 minutes to get some clarity on this topic, but just left with only 1.5 hours, unfortunate today. But next week we'll be able to have the full swing, Niresh, hopefully.
I hope so, yes, I hope so.
I'm looking forward for that. So I leave you tonight with a quote, as I always do. This time around, I flicked this quote from Niresh, who sent me this morning. Democracy does not die with a few major blows, but rather with many small steps. Take care and good night.
Asia Cup, the official broadcaster in Sri Lanka, live from TV1.